We still have an appearance on that.
We didn't receive them, but we're fine.
On the record in the matter of the state of Michigan versus Devon Watt 26-00264. Appearance, please.
Morning, Your Honor. Attorney Bernard Levine on behalf of Devin Watt.
Ross Marchmina filling in for attorney Adam Pfeiffer on behalf of the people.
Today was the date scheduled for probable cause conference. There's an exam scheduled in person at the court on February 20th at 8:30. And so, Mr. Levine, you're going to be filing an appearance on this?
I did, Your Honor, yesterday, and I received an acknowledgement thereof from the clerks at 54A.
Did you receive your discovery?
Yeah, I did receive discovery yesterday as well, Your Honor.
The court did receive a copy of some amendment to contract agreement. We don't know why we received it from Mr. Watt.
I'm sorry, Your Honor.
It's about a pet deposit.
I have no idea, Your Honor. That's news to me, but I'll inquire as to why my client would even send that.
That is an amendment to the lease that was made by the way.
Oh, okay. Yeah, Your Honor, if I could clarify. So before I got on the case, my client was looking to modify one of the bond conditions so as for the no contact to not apply to his physical address. And I'm not sure who told him, maybe one of the clerks, I think my client said, told him to provide quote, proof, end quote. And so he thought he could do that by sending that. I talked to him about it. It's not the way to go about it. So apologies for that.
Okay, so that's something to do with where he's living. Is that what you're saying?
That is correct, Your Honor. Yes. So the
okay, so
go ahead.
We're going to continue to exam next week.
Yeah, yes, Your Honor.
Okay, and what was the issue with the bond condition?
Sure, thank you, Your Honor. So my client was looking to get the no contact to not extend to the physical address, the 1443 Knollwood, and that's where he resides, and the alleged victim doesn't reside there. So he was asking to just modify that bond condition.
Okay, it does not appear that the PA 53 actually lists that address. It just says that he can't live or be wherever Adriana Hill lives, but it doesn't actually list that address. So if she doesn't live there, that's not a problem.
Sure, no, then it shouldn't be then. All right. So I know my client has a copy of the bond conditions. I don't have them yet, so it doesn't appear to be an issue here. Okay.
The address we have her is 6055 Schaefer Road.
Okay, so it's not the Knollwood address.
Okay. All right. And I'll clarify that point to my client, Your Honor. Thank you.
Okay, sounds good. Any additional matters for today's record?
No, Your Honor. Thank you.
Okay, you're all set. Thank you.
Thank you.
State of Michigan versus Jessica By 26-00146. Appearance, please.
Ross Marchmina from the people.
Kyle Strobridge on behalf of the defendant.
Would you find?
Oh, she's right here.
I'm right here.
Come on up.
Okay, today is the date scheduled for a probable cause conference operated while under the influence, causing injury, reckless impairment. Like, are we continuing to examine this?
I believe we are, Your Honor. I do have inquire with the court as far as scheduling. I do have a perfect storm of events going on here. I have a trial scheduled next Friday, then a vacation the following 2 Fridays, and a CDAM training following that. I don't know if the court would allow an off day to do the preliminary exam.
Understand, ma'am. You understand that you have the right to have a preliminary examination within 21 days of the date that you're arraigned? I can't hear you.
Sure.
Okay, I just want to make sure you understand that right. And because your attorney has a conflict, are you willing to waive the timeline so I can reset this?
Yes.
Okay, we can reset it. It's the earliest date we have was probably not until April anyways.
Okay. That should be fine, Your Honor. And we'll continue to work on.
Is March
negotiations.
26th at work?
March 26th, you said?
Yes.
26. Yes, Your Honor.
Will you set this for March 26th? At what time? 8:30. At 8:30? And you received all your discovery?
As far as I'm aware, yes. I have.
Okay. Unless there's any other issues.
I just note for defense counsel's information, we hired a new APA and he'll probably be on the docket by March 26th.
Okay. I'll just be in
We'll just
contact
keep
with
you
your
in the
office.
loop on, you know, who to be in touch with.
Excellent, thank you.
Any additional matters for the record?
Not at this time.
Not for the people.
Thank you. We'll get you a notice for March 26th.
Thank you.
Edward Nicholson was a review. The update for Mr. Lee, because I don't know if he's referring back to competency. I don't know. Mr. Lee is outside. So we don't know if he's getting the competency. Christopher Taylor is on. Zorelli. He didn't have one yet?
Oh, no, he's talked to Taylor and Wiseman, I believe.
Oh, okay, on the record in the matter of the state of Michigan versus Christopher Taylor, 24-00563, appearance, please.
Ross Marchmino for the people.
Excuse me, Jacob Rowley on behalf of Mr. Taylor. Here's my video from the county jail.
I didn't. Did I give you the Taylor card? Today was the date. I'm sorry?
I gave it to.
Addie said she gave it to you earlier.
Oh, gotcha.
Thank you. Today was the date scheduled for a probable cause conference. There is an exam scheduled February 20th at 8:30 in person at the court. Carrying a concealed weapon. Are we continuing to examine?
Yes, Your Honor.
And you received all of your discovery?
Yes.
Additional matters we need to address today?
Nothing for the people.
Nothing from the defense.
Okay, we'll see you in person next week, Mr. Taylor.
Okay.
Thank you. You're free to go.
Okay, thank you.
You're welcome. Who is this? Is that Wiseman?
That is Mr. Wiseman.
State of Michigan versus Alan Wiseman of 26-00323. Appearances, please.
Ross Marsh being up to the people.
Jacob Rowley on behalf of Mr. Wiseman, who's appearing remotely from the county jail.
Thank you. Okay, we have Mr. Wiseman here. One felony count interfering with electronic communications, and then there's a domestic violence. Are we continuing to examine next week on this?
Yes, Your Honor.
Yes.
Okay, Mr. Wiseman, we'll see you in person next week, February 20th at 9 a.m. for your exam. Do you have any questions for the court?
No, ma'am.
Okay, you're all set. Thank you.
Oh, wait, can I make a brief record of
You
something?
may.
I spoke with the complaining witness in this matter yesterday, and she indicated that she's been getting a lot of harassment from third parties trying to get her not to come to court. I don't know if we can establish that this is directly at the defendant's direction, but I do think that it's worth flagging. And if it is the defendant's direction, obviously he's not helping himself by sending people to discourage the victim's participation, would get himself additional charges if that is the case.
Counsel, did you want to respond?
I just said I have not received any evidence of Mr. Wiseman being involved in any sort of prohibited communications, so I just leave it at that.
Okay, Mr. Wiseman, I'm not sure if you heard everything clearly, but there's been some concern or allegations that there's been third parties making threatening communication to the protected party. So I'm going to advise you of the bond conditions, which include a no contact directly or through third party to Ms. Torrey. You understand that?
Yes, ma'am, I do.
Okay, so no one in your family or your associates are allowed to contact Ms. Torrey on your behalf, and especially for the purposes of trying to discourage her participation in this case. You understand that?
Yes, ma'am, I do.
Okay, that's great. That's all we wanted to make sure is that you understood. Any additional matters for the record? You have a question, sir?
I was gonna say, you mean, you could like check the phone records here in the jail. You could.
There was no allegation. There's no allegations that you called from the jail, but thank you for giving us the permission to check the phone records.
What?
Any additional matters for the record?
Nothing for the people.
Nothing for defense, Your Honor.
You're all set for today, sir.
What's Mike Cheltenham doing?
I know.
So is the implication of the case itself just that it allows. the
Mr.
withdrawal?
Perkins, you're free to go, okay?
Okay, thank you.
I mean, I know it goes a long way because like I told somebody came in. I had property, they don't see it, they can see it.
What's your name, sir?
Uh,
Oh, okay. Okay, this is the state of Michigan versus Dashawn Powell, 26-00335. Appearance, please.
Ross Martina for the people.
Does have an attorney, is that correct? Correct. Okay, he was denied. Due to lack of indigency?
They didn't say in the email, just said it was denied.
Mr. Powell, can you hear me?
Yes, ma'am.
Here's you were denied a public defender. Are you employed, sir?
No, ma'am.
Okay. We don't have a public defenders in the building still.
I think they're trying to assign conflict counsel with him. There's a co-defendant by the public defender.
It just says denied in our system.
Yeah, well, in the email they sent me.
Yeah, they told the court denied.
Oh.
See that Raleigh is assigned to the defendant.
Denied and seeking conflict counsel are not the same.
Gotcha.
Okay, Mr. Powell, hang tight. We're gonna see if we can find a public defender, okay?
Yes, ma'am. Appreciate you.
No problem. Let's see here. We did that. Did Mr. Lee come and tell us what's going on with this file? Thank you. And did you see Mr. Lee anywhere?
No, I have not.
So you shoot him an email because he's got a case on my docket today.
Yeah.
Mr. Palmer,
Hi, Judge.
I have a defendant here, Mr. Dashawn Powell. And I think there's a co-defendant. We received notice that he was denied a public defender, but he's unemployed. And your office does represent the co-defendant, so we're just trying to understand why he was denied.
Sure, let me take a look and see if I can tell you something. Otherwise, I'm happy to meet with them and do another intake or something.
Thank you.
None in it. Just the short version is it appears, for whatever reason, I don't know, but it appears that at the time of arraignment, he claimed employment and essentially no bills. And so the denial was made as not indigent because he essentially claimed income with no liabilities. And so they deemed him not indigent. I'm certainly, if he's in fact unemployed or regardless, I guess, let me put it that way, I'm certainly happy to talk to him again and see if I'll do another intake form and see if, obviously we'd have to send him to conflict counsel anyway, but I'm certainly happy to talk to him again.
I'd appreciate if you could do that. He did just report to the court that he was unemployed.
Understood.
And we'll just treat next week as another probable cause conference.
Got it. And he's on Zoom, you said, or?
Yep, he's right there in the jail.
Got it. I'll go, I'll step outside and log in, Judge, and I'll talk to him in the
Thank
breakout room.
LVNV Funding versus Erica Garcia, 25-03522. Council appearance.
Ross first, for the people.
No,
Oh,
LVNV
sorry, I
Funding.
was just spaced out.
No, it happens. When you switch gears
I
like that, it
apologize. Trying to make a career change.
happens. I can't hear you, Mr. Rusin. Are you muted?
I think I am. Can you hear me now?
Yes.
Okay, Judge, may it please the court, I am Attorney Richard Rusin. I'm the attorney of record for the plaintiff. I'm also the petitioner in this motion by plaintiff to reinstate the case.
Okay, and then Erica Garcia, is that your name? Okay, today was the date that was scheduled and set for a hearing. This is for motion to set aside a dismissal, which the court received. Mr. Rusin, you said that you missed court and it was due to a Zoom error
Yeah.
of some sort.
Yes, Judge, if I can clarify, I had an appearance counsel for that hearing. And according to the notes of the appearance counsel, they noted that Ms. Garcia appeared personally in court like she is doing today. And that once let into the Zoom hearing, the court officer informed the appearance counsel that judge was not there, who was assigned to this case, i.e. you, and that your case was being handled by Judge Buchanan. My appearance counsel logged into Judge Buchanan's courtroom where the judge told me they'd waited and then finally dismissed me because apparently you were not there at the hearing and my appearance counsel didn't know to check in to Judge Buchanan until after the case was called and dismissed. So because of that, I've timely filed this motion asking that the case be reinstated. If you do grant my written motion, I see Ms. Garcia is here and perhaps we can conduct a pre-trial.
Okay, yeah, I was definitely not here on December 19th. However, there was someone present virtually for my court to redirect people to Judge Buchanan's virtual courtroom to handle the matter. So I don't know how that's a discrepancy. I think that's pretty clear. My court officer was here to make sure that happened. And I think Judge Buchanan would have not entered a dismissal had that person logged into the Zoom court, but I was again not here, so I couldn't speak to what happened. So it could have just been a discrepancy. I'm going to, for that reason, reinstate the case. And so the parties can meet privately and see if they can resolve it.
Thank you, Judge. I know from my experience with the court that if perhaps Ms. Garcia can go to a private breakout room, which is, outside your court, but around the corner, maybe we can conduct a pretrial there and then bring this case back onto the docket.
Okay, I will get, did you bring a phone with you, ma'am? A phone or a device that you can get on Zoom? Okay, we'll get you on Zoom and then you can meet with Mr. Rusin and see if you all can either resolve this matter or do a joint pretrial statement so that we know how to proceed, okay? Thank you.
Okay, not to use paper.
No, I was just kidding. Yeah,
I found it.
did the defendant make a statement to the police?
No. It's gonna be short.
Okay, on the record in the matter of Dominique Houston versus Lori Herby 25-04186R. Appearance, please.
Yes.
What does yes mean? Are you Dominique Houston? You need to start your
Yes,
video.
ma'am, I am.
I can't see you.
You-
Okay, okay. State your name for the record.
My name is Dominic Houston.
Okay, and then Lori Herby present?
Yes, ma'am, I'm here.
Okay. All
I
right,
also
so
ha-
this was,
I also have my guardian here, David Jones. He's on the line. He filed the motion.
okay. Yeah, your guardian can obviously be here, but is not able to represent you in court. Only an attorney can represent someone else in court, okay?
No problem.
Okay, so this is a motion to set aside a default judgment. It looks like a default judgment was entered by Judge Buchanan in my absence. And this was, there was a motion that was filed that said that Ms. Herby was not served. And I guess that the meritorious defense would be that she does not have possession of the items sought. So Mr. Houston, you're suing, this is a lawsuit for a washer and dryer, is that correct?
Correct.
Okay, so in order, Ms. Herby, for me to set aside a default judgment, you gotta give the court two things, good cause and meritorious defense. It's clear what your meritorious defense is in the motion that you filed. You're saying you don't have the washer and dryer, you left it in an apartment. But what is the good cause as to why, I guess that you're saying you weren't served? You were not served with the lawsuit, ma'am?
No, ma'am. It was served to my neighbor.
Let's see here. Who is Cheryl Polk, Mr. Houston?
My neighbor.
Cheryl Polk is her next door neighbor, and her next door neighbor served her.
The next door neighbor told you that she served her, or is that what you're saying?
She served her and she signed the documentation. It was turned into the court as well.
Okay, what I'm asking you was the next door neighbor said that she served her, because how do you know that she in fact served her?
He told me that she served her and she signed the documentation.
I'm not asking you to sign documentation. I've obviously see her name there. That's why I'm asking you who she is.
Yes, ma'am.
Okay, and she stated that she did this on the 16th of July, 2025 at 5:30.
Yes, ma'am.
Okay, I see here that the acknowledgement of service has not been completed. Did you notice that needed to be completed?
Said I didn't quite hear you, Judge.
The acknowledgement of service is incomplete.
Well, I did not know it was incomplete.
It's left blank is what I'm telling you on the proof of service.
Okay, well, I did not know that.
Okay. And so Ms. Herby is saying here on this court record, she never received. Is that what you're saying? How did you know that you were being sued, Ms. Herby?
He told me.
You said what?
Dominique told me.
What do you mean he told you?
Judge, I have a traumatic brain injury, so I would really like it if David could speak for me, my guardian. He's on the call. Is that okay?
He can't tell me, David can't tell me what Mr. Houston told you. That's inadmissible in a court. So you can take your time, that's fine. But if you're saying that you found out from Mr. Houston, I just want to know what happened that you found out about it.
I am at a loss for words at the moment, Judge. But yeah. But I have a conservator and I have a guardian, and I believe I should have not been sued because I have a conservator. So because I have a brain injury and I'm an incapacitated person.
Okay. Okay, Mr. Houston, you told her that she was being sued?
LaShawn was served those papers, Judge. That's how she knows she was being sued.
You didn't answer my question, so I'm gonna grant her a motion. A motion is set aside, the default judgment is granted. If I ask a direct question, I expect a direct answer, not the answer you want me to hear. So evading my question tells me what I need to know. We'll set this matter for a new date for a pretrial. This is general civil or small claims?
Small claims.
Oh, general civil?
It's a GC. Yeah.
Okay, it's general civil. I'm gonna need everybody to come in person for a pretrial.
Okay. I'm in Texas at the moment, but that's fine.
March 5th at 1:30.
When will you be back, or when you expected to be back in Michigan? Are you?
The 23rd is my flight day.
This month?
Yes, ma'am.
This month?
Yes, ma'am.
Okay, I'm setting for a pretrial. March, you said?
March 5th at 1:30.
March 5th at 1:30 in person at the court.
Okay.
Any questions for the court today, Mr. Houston?
No, ma'am.
Okay, we'll see you on March 5th. Any questions for you, Ms. Herby?
No, ma'am. Thank you.
We'll see you March 5th.
Okay.
Mr. Palmer.
Yes, ma'am.
Were you all set with Mr. Did I give you the file?
Powell, you didn't give me the file, but I spoke with him.
I meant, I gave you the file.
Sorry.
No worries.
Sorry.
Okay, let's see. So I'll treat next week as another probable cause conference.
Okay.
And then hopefully we'll get an update then about what's going on.
For what it's worth, Judge, I don't know if you want me to put this on the record or not, but I can just tell you that for what it's worth, it appears that what occurred is that Mr. Powell did report employment. However, what actually happened and this didn't get communicated from the arraignment attorney, what actually happened is he was supposed to start employment, and got arrested before his employment actually started. So I do think he's unemployed, as he's advised the court, and clearly he will qualify for representation. As soon as I'm done with my other matter, Judge Ward, I'll go back and make sure that Mr. Powell's assigned representation. He was polite and respectful and provided all the information I needed to get that to happen, and he's obviously entitled to counsel.
Wonderful. Thank you so much, Mr. Powell. We'll see you next week. Hopefully you'll have attorney by then, okay?
Yes, ma'am, appreciate you.
Thank you. Thank you, Mr. Palmer, and best wishes to you.
Thank you.
Mr. Lee?
Good morning, Your Honor.
Good morning. Were you aware that you had a matter on my docket today?
I was not. I apologize.
Okay, there is Mr. Edward Nicholson. It looks like this matter was set today because the plea he attempted failed on the 8th, it looks like, because he was struggling to comprehend his rights. And we were not clear if it was your intention to file another competency petition, so we need an update.
Yes, Your Honor. I have spoke with the management team here at the Public Defender's Office, and I have been approved for an independent examination. The psychiatrists that we would normally use in this situation have retired, moved away, etc. And the one that Mr. Cornish was using, he said would take too long. So I'm currently looking for somebody who can get this done as quickly as possible.
Okay, when do you think that you'll be able to give us some more detail?
I hope within the next 2 weeks, I should know something solid on this, Your Honor.
We're gonna reset this review and we're gonna give you the date now.
We can do February 27th at 9.
February 27th at 9, okay?
Yes, ma'am. Thank you.
Thank you. Is Curtis DeYoung here?
Yes.
Is that you? Okay. And someone's here for Spring Oak?
Yes.
Okay.
Yes, Your Honor. Michelle Bourne Fisher on behalf of plaintiff.
I've not officially called the case. I was just checking. Thank you. I have too many things open here. Let's see if I can close this. I think that's all the criminal stuff, right? Thank you.
Your Honor.
Same to you. Have a good weekend.
I'll let you guys get another trial next week.
You do.
Every week.
This is the trial court now.
Well, it's in the trial court. That's why the court rule says all trial court get paid the same. We just actually run trials now.
5 trials.
I'm about to have.
I think you might have been the person who started this.
I'm about to have 3 weeks in a row without a trial. I don't think we're
No
gonna
way.
have one on Monday.
No way, without a trial.
I know.
Because you can't do that.
I
No
live
up
in
for
the good
jail.
Do you
life.
give offers? Is that what's going on over
You
there?
can't do no up
That
for
was-
jail if there's a prior
Okay, no.
assault.
That's even,
No front jail is not an offer.
so for a while, I had defense attorneys who were not skilled at persuading their clients to act in their best interests.
Got it. It is what it is. Well, it is what it is.
And now I have defense attorneys who are skilled at persuading their clients.
So now you don't have any trials, and now you're bored.
I'm losing time.
Oh, I see.
Been having so much fun with Tyler Smith. Maybe I'll have fun with George. I don't know.
George is fun. I think you're gonna have fun with George.
He's a character, that's for sure.
Everyone loves George.
You and George, that's pretty fun.
Mr. Ryan?
So I was just trying to start. The attorney earlier said he had called. He did, he called me late. And I let him know he was here. He wronged me. And by the time Jeff was in all this.
Kristen, did you and Ms. Garcia work out a joint pretrial statement or a resolution?
Judge, I have a consent judgment that I can put on the record with Ms. Garcia when Ms. Garcia is ready to go on the record with you and I.
Thank you. Back on the record in LVNV Funding versus Erica Garcia, 25-03522. Counsel, can you put the terms of the consent judgment on the record?
Thank you, Judge. May it please the court. For the record, I am Attorney Richard Bruson. I am the attorney of record for the plaintiff, and my bar number is 35222, Judge. I can tell you that while the case was in recess, with the parties being in the breakout room, Ms. Garcia and I discussed the parameters of this case and have agreed to enter into a consent judgment whereby judgment will enter in the amount of the complaint for a defaulted credit card assigned to the plaintiff, and that was in the sum of $598.15. I explained to Ms. Garcia that in Michigan courts and in Michigan law, there are what are called taxable costs. And I explained to Ms. Garcia what those meant. And in this case, they involve a $35 summons filing fee and a $37.93 summons service fee. And I explained to Ms. Garcia that by law, the legislature grants me a $75 statutory attorney fee concurrent with the entry of these sort of consent judgments, so that the total amount of the consent judgment, Your Honor, will be in the amount of $746.08. More importantly, I explained to Ms. Garcia that there will be concurrent with the entry of this consent judgment a $40 monthly installment order right on the face of the judgment, which will begin March 15th, 2026. And then each 15th day of the month thereafter, I explained to Ms. Garcia the best way to get those monthly payments to my office. And I verified with Ms. Garcia that her residence is still current for the purposes of having notices sent by the court to her Ontario Street address, which is on her answer to the complaint. Finally, Judge, as I explained to Ms. Garcia while the case in recess, as I do now, I asked Ms. Garcia's permission to sign her name to the proposed consent order with those terms and installment payment so that I can electronically file that with the clerk of the court by the end of business today. Your Honor, with that, I rest.
Oh, thank you. And that, Ms. Garcia, is accurate? Okay, you understand that you had the right to proceed to a trial on this matter? You want to waive that right? And you don't want to get an attorney to represent you, correct? Okay, and did you give the council permission to sign this agreement on your behalf? Or
I was gonna sign it. He asked if I can sign it.
did you electronically sign it?
No, I don't.
Well,
You're
I think
asking
this
her
is,
to-
yeah, this is an e-file court, so I expect it to be e-file, with the court.
Okay, she said that you asked her if she could electronically sign it.
No, I.
Maybe he's asking for your, he's likely asking for your permission to put your signature on the document he just did.
Okay.
Okay, did you give that permission?
Yes.
Okay, so he can electronically file it or go to me. I will review it to make sure it comports with what was stated on the record, and then I'll sign it, okay? Do you have any questions at this time?
No.
Any additional matters for the record?
Judge, this
Counsel?
is the plaintiff rests.
Thank you, you're all set.
Thank you.
You're welcome.
Thank you, Ms. Garcia. Thank you, Your Honor.
Thank you. Okay, Spring Oaks Capital versus Curtis DeYoung, 25-04202.
Michelle Bourne Fisher. Sorry, Michelle Bourne Fisher, P67527 on behalf of Spring Oaks Capital.
And your name, sir?
I am Curtis DeYoung, the defendant, appearing pro se.
Okay, today was the date that was scheduled for a motion for summary disposition, and then I think the defense filed a motion to strike pleading, to which I did receive responses for both. And the motion for summary disposition in response, so you filed not a responsive motion, but a motion to strike the pleading?
A motion to strike plaintiff's affidavit of accounts and exhibits to their motion for summary disposition.
Okay, and did you receive their response to your motion to strike?
I did not.
Okay, so they did file a response to your motion to strike, to which the court is in receipt. Let's see. When was that filed, counsel?
Well, there was he should have received his copy that was mailed out on the 10th. The court, there was an issue when we e-filed it. Apparently we filed our response and proof of service as one document. So it got kicked back, so we refiled, but it appears that you do have that. And it would have been.
Okay, so if he filed it on the 10th, he would not likely receive it because today's the 13th. It's possible they didn't get it.
Possible.
Okay. Okay, so you can respond on the record, counsel.
Respond to his motion to strike?
Yes.
Okay. So it's filed as a motion to strike, and I will address the motion to strike portion, but there are a lot of other things in his motion to strike which are not, they don't really go to MCR 2.115B. They're more so things that should have been raised as affirmative defenses in his initial pleading, and they were not. So those are waived. I'll note that the initial response to the complaint didn't comply with the court rules at all either. Regarding the motion to strike, the court rule indicates that the court may strike from a pleading redundant, immaterial, impertinent, scandalous, or indecent matter. Defendant has made no showing or offered any evidence that what we provided in our pleadings, both in our complaint and our motion for summary, would fit into those issues. If you'd like me to address the other things that he brought up, I can. But again, it's our position that those are defenses that should have been raised in the initial pleading and are such waived.
Thank you.
Yes, Your Honor. So thank you for the court's time. I'll keep this focused and rule-based. This motion is not about credibility or weighing evidence. It raises a threshold legal issue, whether the plaintiff's affidavit and exhibits are admissible at all. The controlling rule under MCR 2.116 G6, the court may consider only substantively admissible evidence at summary disposition. Under MCR 2.119 B1, an affidavit must be based on personal knowledge, set forth facts admissible in evidence, and affirmatively show the affiant's competence. As the Michigan Supreme Court held in Quanto versus Cross and Peters, the burden never shifts unless admissible evidence is first presented. And my first point that the affidavit must be stricken is that it's a failure of service. And
You said it was a failure of service?
yes, ma'am. And plaintiff's motion for summary disposition, they claim they followed the Michigan court rules and filed the affidavit with the complaint. However, my complaint did not contain that affidavit. Also, I came up here February 2nd prior to filing my motion to strike and spoke with the clerk and asked them to print me off a copy of the original complaint that was filed by the plaintiff. And that too did not include the affidavit. Where there are 3 arguments in their summary disposition are based on filing a counter affidavit, consent to amount sum, and account stated. And all 3 of those arguments are mischaracterized the record.
Okay. And did you want to respond to the statement that was made in their response to your motion to strike, which is essentially your response to their summary disposition really isn't reads like it's something that you should have filed when you filed your answer, which we call your answer and affirmative defenses.
Right. I disputed in my affidavit, which was my answer here with the complaint. I cannot file a counter affidavit to an affidavit that was not filed with the complaint. So but however, I did file the affidavit without their copy of their affidavit. And I can read it for the record, which clearly disputes their claim here. On January 23rd of 2022, I disputed this account with a previous debt collection agency. After the dispute, the agency that was being disputed stopped reporting, stopped contacting me. The plaintiff with Spring Oaks Capital, their bill of sale does not show any information pertaining to the account that is mentioned in the claim. There is no signed contract between the defendant and their claim and the claimant. I did not consent to a sum due. There is no written or verbal consent. I did not authorize Spring Oaks Capital to purchase or buy a debt. I have not received periodic billing statements during this question. In question, I was living in a different area at that time. I did not have an active phone and could not be reached at that time either. Spring Oaks Capital has not reported on my credit report until May of 2025. Soon after this time period, they filed the suit. Their bill of sale, Your Honor, predates the creation of the original creditor's account. So how can you transfer, assign, or sell something that does not yet exist? Their purchase agreement has a cutoff date of June, I believe it's June of 2022, or July 20th of 2022. However, the assignment says July 28th of 2022. You cannot assign something that's, the document's already been cut off. You can't assign something after that date. The purchase agreement is also signed by Spring Oaks Capital SPV and Spring Oaks Capital LLC, which is an internal transfer and is signed by the same president and CEO. It's not a transfer from the original creditor to the plaintiff here.
Okay, so let me stop you. Are you disputing the validity of the transfer or the validity of the actual original debt? Because you say you disputed it on your credit report with another creditor?
Yes, it was reported on my credit report by a Tombstone Bank of Missouri.
Okay.
I disputed it with them.
Why was that?
Why was that? That account is not mine. I did not.
You never opened any such account?
I'm not here to dispute that.
No, you're here to answer my question. So you never opened any such account, is what you're saying?
Not with the plaintiff, no, ma'am.
No, that's not what I asked you. I'm asking you about what you disputed. That you brought up in this court. I didn't bring that up, you did. So you say you.
I disputed that I never opened up an account with Tombstone.
With Tombstone, okay. Okay, so the original, let me open the original complaint here. The original complaint states or alleges that you had an account with the Bank of Missouri. Is that accurate?
They said I opened it.
No, I'm asking you a question. Is that accurate?
I did open an account
With
with-
Missouri?
through Genesis FS Card Services.
Okay.
That's who I got the open an account with.
Okay, and so I'm trying to figure out where your dispute it triggers. Is it you're disputing that they now own this debt?
They do not own.
Is that, you
Yes,
answer the
ma'am.
question, you can't tell me if they own it or not. Are you disputing that? Because
Yes,
that's a
ma'am.
question, I gotta decide that. You
I'm
can't.
disputing that Spring Oaks Capital SPV does not own this debt, and all of their exhibits contradict their claim.
Okay, thank you. Counsel, did you want to respond?
Yes, I'm showing that this account was opened on October 27th of 21. If you'll see the bills of sale we attached, let me get the date. July 28th of 22. So it doesn't, the bill of sale doesn't predate the opening of the account.
It does. Can I respond to that?
You may.
Okay, their bill of sale has a closing date of July 28th of 2022. This bill of sale is between Genesis F Card Services in consideration of purchase price. It does not state any of the defendant's name, account, or anything. It is generic files.
Does
And under
it have account number on there?
It does not. It does not have the defendant's account
Can you
name.
show me what he's looking at, please? Okay, so you're seeing a bill of sale, and so this is from an agreement from June 8th, 2021, receivable sale agreement dated June 8th, 2021, bill of sale closing date July 28th, 2022. Genesis Card Services, what is the issue? You're saying that the
defendant's account is not mentioned in the sale at all, and I have case law or statutes that state that generic files are not admissible evidence to.
Okay, well then all this does is create a question of fact. It doesn't.
So material fact, right?
Yeah, so first, as it relates to your motion to strike, I'm denying that. We're not just striking their pleadings based on the fact that you have some affirmative or what you believe to be affirmative defenses. You can present those at the time of trial, okay? So your motion to strike is denied. As it relates to their motion for summary disposition, I think that obviously you've got some evidence that you believe poses a question of a fact that the court needs to hear further on. So I don't think that this is right for disposition. I think this matter needs to continue. I'm denying the motion for summary disposition. Is there already a trial date on this?
It was today.
Oh, today was the trial date.
At 1:30.
At 1:30.
Your Honor, is it possible for me to
see today?
Is it
You can
possible
respond.
to respond to, so when he talks about the bill of sale, there's a schedule attached, which does have his specific account information.
Okay.
We also attached to our motion for summary disposition is the affidavit of ownership and indebtedness. So I don't believe that's an issue.
It was not filed with the complaint.
It doesn't have to be.
They state under Michigan
I'm
court
not,
rules.
I've already made a ruling that you all gonna be here at 1:30 for trial, because we're not taking up any more time this morning for this.
Yes, ma'am.
Counsel?
I'll be here at trial.
1:30 for bench trial?
I would ask for an adjournment, Your Honor.
I'm ready for trial, ma'am.
Today's the date and time scheduled for trial, so we can't just adjourn. For what reason?
Well, for the reason it should be, his answer, nothing so far that defendant has presented. He's raising affirmative defenses now that have all been waived.
No, they have not. You waived them, and I have.
Do you all want to talk privately to see about this, because that's what you're
No,
talking
ma'am,
to?
I'm ready for trial.
Okay.
Can I bring up, I'm sorry to cut you off. Their witness list, it's Jane Doe and John Doe. How do I cross-examine witnesses in trial if they do not have a valid witness?
Are you expecting witnesses to appear at your trial, counsel?
No, I don't believe we are.
Okay, the witness does say a representative from Spring Oaks and a representative from Spring Oaks. That was just in case that you believe that you were going to have to call a witness. Well, I guess you would likely have to call one. Let's see, and you intend to call the defendant as a witness?
Correct.
Okay, let's see.
I don't see, did Mr. DeYoung file a witness list and exhibit list?
File a witness list or exhibit list?
No,
Did you have to file an exhibit list?
I did not file an exhibit list.
Did you give them a copy of your exhibits?
I mailed them a copy of what the court has on file.
No, Your
You
Honor.
mailed them a copy of your exhibit list?
No, ma'am.
I did,
Just
I
what the court
issued
has
a
on
pretrial
file.
order stating that they needed to be exchanged 1 week prior to trial.
Well, the plaintiff's complaint is,
I'm not talking about the complaint.
well, I
I'm
didn't
talking
file an
about your exhibit list, because you have some exhibits there.
I just going off what the complaint is. That's all I'm going off of.
Well,
Their
no,
bill of sales.
for you to make a defense, you're gonna have to admit some evidence. You have exhibits to admit as evidence?
Yes, ma'am.
That's what I'm saying. You were
Can I
supposed
enter
to,
those today?
you can give them to her today. You can't enter them until they're properly transferred to her. Just like she's got to give you a exhibit list, you had to give her one too. And you're not calling any witnesses I'm assuming you're gonna call yourself?
Yes, ma'am.
Okay. I'll reset the trial. You're not prepared.
So right now I'm just lacking the exhibit list, ma'am.
Provide them with an exhibit list. And if you have a witness list, that as well. Is it, Giovanni Washington? Yeah. Okay. We can do March 30th at 9. Does March 30th work for you, counsel, at 9?
Yes.
Okay, we'll do March 30th at 9 a.m.
I do have a question too, if I may.
Yes.
I know that you denied defendant's motion to strike. So first, I need to know who's going to prepare the order for that.
If you can prepare an order denying both the motion to strike and the summary disposition, that'll
Okay.
satisfy both.
And my second question is, because there's been no written response to our motion for summary, are we able to, before the next trial date, file another motion for summary under 2.116 G4? His failure to respond in writing, our motion for summary should be granted.
Yes, you can file another.
I did file a response in opposition to plaintiff's motion for summary disposition.
I did not receive that. If you did.
I mailed them a copy of
Let's see. I see your motion is strike. I don't see any other filing since then.
it was all one packet. There's filed in the packet for everybody.
You get what he's filing. Okay, defendant's reply in support of motion to strike and in opposition to plaintiff's motion for summary disposition.
Is that one document? I have defendant's motion, right?
It's one document.
Is that what you have was filed with the court? My filing with the court says defendant's motion to strike plaintiff's affidavit and exhibits. There's no mention of a response to our motion for summary. So is this a new document that he?
There, no, this is actually, this is in here. This was, they entered it into my file separately. So one, it looks like they entered as a motion, the motion to strike, and then attached this as the brief to that motion. So under the brief, it was the defendant's reply in support of motion to strike and in opposition to plaintiff's motion for summary disposition.
Okay, I do not have.
I do see that in my file. They filed it as a brief, although it's really not a brief, but. Okay, let's see. We'll do March 30th, 9 a.m. We'll get you a notice to appear. I'm just gonna scan this. As counsel, I still will allow you to file another response, motion for summary.
Okay, thank you.
Prior to that date. Any additional matters for this record?
No, well, just a question on the date. So when she files her summary disposition, that's going to be filed within 7 days of trial?
That'll be filed prior to the 30th, because if she files it, we're gonna have to hold the hearing on the 30th. She needs to get that to you, I think 7 days prior, to get you an opportunity to respond. You'll also probably be receiving their response to your motion to strike at some point, because it looks like they just filed or sent that response to you. So you'll be getting that as well. So counsel, you think if you're going to file a motion, another motion for summary, that you will have that filed no later than the 23rd of March?
No, absolutely, yeah, we'll have it
And they
before.
can use their same exhibits on the next summary disposition?
They can use this, they don't need to file a new exhibit list. They're all set. Okay. Yep, they're all set.
Thank you, ma'am.
Thank you. Thank you, counsel.
Thank you. Have a good day.
You too. Let's see. Mr. Washington is here, and is Mr. Meek the attorney on that? Yes. Okay, LVNV Funding versus Giovanni Washington, 25-07760.
Good morning, Your Honor. Yeah, Preston AP 77884, appearing for LVNV.
Okay, and then I see Mr. Giovanni Washington is present. Mr. Washington does not have an attorney, correct?
I believe that's correct.
That's correct.
Mr. Washington, okay, did you all complete a joint pretrial statement or come to a resolution?
We did. Mr. Washington's working with the debt settlement company, so while they're figuring out that resolution, we went through that pretrial statement that I can submit to the court.
Very good, okay. Okay, any additional matters that we should address on the record today?
No, I think that was it. Thank you.
Do you have any questions, Mr. Washington?
No, ma'am.
Okay, you're all set. Thank you.
Have a good
Thank you.